I came home from a 12-hour shift at the hospital in Portland, Oregon, to find a bright yellow boot clamped onto the front wheel of my Tesla Model 3, which was parked exactly where it should have been, inside my own garage. The sheer audacity of what I was seeing made me stand there for a solid 30 seconds, my brain refusing to process the reality in front of me. Someone had entered my private garage, accessed my private property, and immobilized my vehicle without my permission or knowledge. My name is Marcus Chen, and I'm an emergency room physician at Providence Portland Medical Center. I'd bought my townhouse in the Meadowbrook Heights community 6 months earlier, attracted by the modern architecture and the promise of a quiet, well-maintained neighborhood. The homeowners association seemed reasonable enough during the buying process. The monthly fees were a bit steep at $280, but the amenities included a gym, pool, and landscaping services. What I hadn't counted on was Brenda Carmichael, the HOA board president who seemed to believe her position gave her unlimited authority over every single aspect of our lives. I pulled out my phone and took about 20 photos of the boot from every conceivable angle, documenting the violation. The boot itself had a company name emblazoned on it, Quick Lock Towing and Recovery, along with a phone number. There was also a bright orange sticker plastered on my driver's side window that read, "Violation, Unauthorized Vehicle. Contact HOA immediately." My hands were shaking, not from fear but from pure rage. This was my home, my garage, my car. I dialed the number on the boot, my jaw clenched so tight I could feel a headache forming behind my eyes. A gruff voice answered on the third ring. "Quick Lock Towing, this is Dave." "Hi, Dave. My name is Marcus Chen, and I just got home to find one of your boots on my car in my private garage. I need this removed immediately." There was a pause on the other end. "What's the address?" 42 Meadowbrook Lane, unit number 7, but I think you're missing the point here. This is my private garage. Someone had to have entered my property without permission to do this. Dave sighed, and I could hear papers rustling. "Yeah, I see the work order here. We were contracted by the Meadowbrook Heights HOA. Says here the vehicle was in violation of parking regulations. In my own garage." My voice was rising despite my best efforts to stay calm. "How is that even possible?" "Look, man, I just follow the work orders we get. You'll need to take this up with your HOA. The fee to remove the boot is $350 plus a $50 administrative charge. $400? You've got to be kidding me. I'm not paying a single cent." "This is illegal. You entered private property without the owner's consent." Dave's voice hardened. "The HOA gave us authorization. We have it in writing. If you don't pay the fee, the vehicle will be towed within 24 hours, and that'll run you another $600 plus daily storage fees." I hung up before I said something I'd regret. My next call was to the non-emergency police line. I explained the situation to the dispatcher, who seemed sympathetic but ultimately told me that since it was a civil matter involving the HOA, they couldn't intervene unless there was evidence of criminal trespass or property damage. She suggested I document everything and contact an attorney. By this point, it was almost 8 in the evening. I was exhausted, hungry, and furious, but I wasn't about to let this go. I pulled up the HOA contact information from my welcome packet and found Brenda Carmichael's phone number. She answered on the first ring, her voice saccharine sweet. "Meadowbrook Heights HOA, Brenda speaking. Brenda, this is Marcus Chen from Unit 7. I need to know why there's a boot on my car in my private garage." The sweetness evaporated instantly. "Mr. Chen, your vehicle was in violation of community standards as outlined in Section 12, subsection 4 of the HOA Covenants, Conditions, and Restrictions." "Which says what exactly?" "All vehicles parked on community property must be registered with the HOA and display the appropriate parking permit. Your vehicle has no permit. I took a deep breath, trying to keep my voice level. Brenda, my car is in my garage. That's not community property, that's my property. The garage is part of the community structure and therefore subject to HOA regulations. You should have received your parking permit in your welcome packet. Since your vehicle displayed no permit, it was marked for boot and potential tow. You had someone enter my garage without my permission. That's trespassing. Brenda's laugh was sharp and humorless. I'm afraid you're mistaken, Mr. Chen. As per the CC and Articles you signed when you purchased your property, the HOA retains the right to enter any part of the community to ensure compliance with regulations. That includes garages. I suggest you read your paperwork more carefully. Now, if you want that boot removed, you'll need to pay the fee and come by my office tomorrow to pick up your parking permit. Good evening. She hung up before I could respond. I stood in my garage staring at my immobilized car, feeling like I'd stepped into some kind of dystopian nightmare. I'd bought this place. I owned it. And yet someone had just claimed the right to enter my private space and hold my property hostage over a parking permit I'd never been told about. I went inside and immediately started going through all the paperwork from my home purchase. The CC&R document was 147 pages of dense legal text. I made coffee and started reading, highlighting anything related to parking or HOA access rights. What I found made my blood run cold. There was indeed a section about parking permits, buried on page 93. It stated that all vehicles must display an HOA-issued permit when parked on community property. However, the definition of community property was vague and seemed to primarily refer to common areas like the parking lot, streets, and visitor spaces. There was no explicit mention of private garages being included in this definition. More troubling was Section 7, Subsection 2, which granted the HOA reasonable access to individual units for the purpose of maintenance, inspection, and enforcement of community standards. The word reasonable was doing a lot of heavy lifting there, and I was pretty sure that entering someone's garage to boot their car didn't qualify. I spent the next hour researching Oregon HOA laws online. What I learned was both encouraging and frustrating. Oregon law did give HOAs significant power, but it also placed limitations on that power. Specifically, HOAs couldn't violate an owner's reasonable expectation of privacy, and they had to provide notice before entering private areas except in emergencies. A missing parking sticker definitely didn't constitute an emergency. I also discovered that booting a vehicle on private property without the owner's consent was legally questionable at best. Several court cases in Oregon had ruled that such actions could constitute unlawful detention of property, especially when done without proper notice or due process. By midnight, I had a plan. First thing in the morning, I'd contact a lawyer who specialized in HOA disputes. Second, I'd file a formal complaint with the HOA board. Third, I'd refuse to pay the boot removal fee and see if they actually tried to tow my car. If they did, I'd have even more ammunition for a lawsuit. I barely slept that night, my mind racing through various scenarios and arguments. When my alarm went off at 6, I was already awake, staring at the ceiling. I got up, showered, and made breakfast, then started making calls. The first attorney I contacted didn't handle HOA cases. The second one did, but was booked for the next 3 weeks. The third one, a woman named Patricia Hoffman, agreed to see me that afternoon. Her voice on the phone was crisp and professional, and when I briefly explained the situation, she made a sound that was almost a laugh. They booted your car in your own garage. That's a new one. Come in at 2 and bring all your paperwork, including photos of the boot and any communications with the HOA. I thanked her and hung up, feeling a small measure of relief. At least I had someone on my side who understood the legal landscape. My shift at the hospital didn't start until 3, so I had time to handle the HOA meeting first. I drove my backup car, an old Honda Civic I kept for situations exactly like this, to the HOA office located in the community clubhouse. The building was nice enough, with a lobby area that had been decorated with generic landscape paintings and artificial plants. A receptionist sat behind a desk, typing on a computer. "I'm here to see Brenda Carmichael," I said, keeping my voice neutral. The receptionist, a young woman who looked barely out of college, glanced up. "Do you have an appointment?" "No, but this is urgent. She had my car booted yesterday, and I need to discuss it with her." The receptionist's eyes widened slightly, and she picked up her phone, murmuring something I couldn't quite hear. A moment later, she nodded at me. "She'll see you." Down the hall, second door on the right. Brenda's office was exactly what I expected. Meticulously organized, with motivational posters on the walls and a large desk that created a barrier between her and visitors. Brenda herself was in her mid-50s, with short blonde hair styled in a severe bob and glasses that hung from a chain around her neck. She looked up as I entered, her expression neutral. "Mr. Chen. I assume you're here about the parking situation." "That's right. I want to know under what authority you had my car booted in my private garage." Brenda leaned back in her chair, folding her hands on her desk. "As I explained on the phone, your vehicle was not displaying the required parking permit. This is a violation of community standards." "My garage is not community property. It's private property that I own. The CC and Articus clearly state that all areas of the community are subject to HOA oversight. That includes individual units and their attached structures." I pulled out my phone and opened the photos I'd taken. "You had someone enter my garage without my knowledge or consent." "That's trespassing, Brenda. Oregon law requires notice before the HOA can enter private areas except in emergencies. A missing sticker is not an emergency." Her jaw tightened. "We have the right to ensure compliance with community standards. If you had registered your vehicle as required, this wouldn't have happened." "I was never given a parking permit or told I needed to register my vehicle. I've lived here for 6 months, and this is the first I'm hearing about it." All homeowners receive a welcome packet with complete information about community rules and regulations. If you failed to read it, that's not the HOA's responsibility. I pulled out my copy of the welcome packet I'd received when I moved in. "This is everything I was given. There's no mention of parking permits in here, no registration form, no instructions, nothing." Brenda's eyes narrowed as she looked at the packet. For just a moment, I saw uncertainty flicker across her face, but it was gone in an instant. Then there was an administrative error. "Regardless, ignorance of the rules is not an excuse for violating them. So you're admitting that I was never properly informed of this requirement." "I'm saying that the rule exists and must be followed. Now, if you want the boot removed from your vehicle, you'll need to pay the fee and complete the vehicle registration form." She pulled a form from her desk drawer and slid it across to me, along with a small blue sticker. "Fill this out, pay the $400 boot removal fee, and you'll be in compliance." I didn't touch the form. "I'm not paying anything. What you did was illegal. You entered my private property without notice or consent, and you're holding my vehicle hostage over a rule I was never informed about. I want the boot removed immediately at no charge, and I want a formal apology." Brenda's expression hardened into something cold and mean. "That's not going to happen, Mr. Chen. The boot stays until you pay, and if you don't pay within 24 hours, your vehicle will be towed at your expense. Those are the rules. Then I'll see you in court." I walked out before she could respond, my heart pounding. I'd never been the type to engage in confrontation, but there was something about Brenda's smug certainty that ignited a fire in me. She genuinely believed she had the right to do whatever she wanted, and I was going to prove her wrong. My meeting with Patricia Hoffman went better than I could have hoped. Her office was in downtown Portland, a sleek space with modern furniture and a wall of law books that probably cost more than my car. Patricia herself was in her early 40s, with dark hair pulled back in a ponytail and sharp, intelligent eyes that seemed to miss nothing. I walked her through everything that had happened, showing her the photos, the CC&Rs, the welcome packet, and my email exchange with Brenda. She listened carefully, occasionally making notes on a legal pad. When I finished, she sat back and tapped her pen against her desk. This is actually a pretty clear-cut case of HOA overreach. Oregon law is very specific about when and how an HOA can enter private property. They need to provide reasonable notice except in genuine emergencies, and they need to have a legitimate reason for the entry. Booting your car over a parking sticker doesn't meet that threshold. So what are my options? Several. First, we can file for an emergency injunction to have the boot removed immediately. Given the circumstances, I think a judge would grant it. Second, we can sue the HOA for trespassing, unlawful detention of property, and violation of your rights under Oregon's Planned Community Act. Third, we can file a complaint with the Oregon Department of Justice, which oversees HOA conduct. What about the towing company? They're the ones who actually put the boot on. Patricia nodded. Good question. If they entered your property based on false or misleading information from the HOA, they might actually be witnesses in your favor rather than defendants. Towing companies don't like getting dragged into legal disputes. If we can show that the HOA misrepresented the situation to them, they might cooperate with us. How much is all this going to cost me? My retainer for HOA cases is $5,000. Given the strength of your case, I think we can resolve this relatively quickly, either through settlement or summary judgment. You'll likely recover your legal fees if we win, plus damages for your time and trouble. I thought about it for maybe 10 seconds before nodding. Let's do it. Patricia smiled, a predatory expression that made me glad she was on my side. Excellent. I'll draft the paperwork today and file it tomorrow morning. In the meantime, don't pay that boot fee. Don't sign anything from the HOA and document everything. If they tow your car, let them. It'll just add to the damages. I left her office feeling energized and vindicated. For the first time since finding that boot, I felt like I had some control over the situation. The next morning, I woke up to find my car exactly where I'd left it, still booted. I took fresh photos with that day's newspaper in the frame to establish the timeline, then headed to work. My shift at the hospital was brutal. We had 3 trauma cases come in back-to-back, and I didn't get a break until almost midnight. When I finally checked my phone, I had 7 missed calls and a dozen text messages. The first voicemail was from Patricia, her voice calm and satisfied. Marcus, it's Patricia Hoffman. I filed the emergency injunction this morning. We have a hearing scheduled for tomorrow at 10. The judge's clerk indicated he's inclined to grant the injunction, so that's good news. Call me when you get this. The second voicemail was from Dave at Quick Lock Towing, and his tone was completely different from our first conversation. Mr. Chen, this is Dave from Quick Lock. I need to talk to you about the boot on your vehicle. Please call me back as soon as possible. It's important. The remaining voicemails were from Brenda, each one progressively more agitated. Mr. Chen, I've been informed that you filed a lawsuit against the HOA. This is completely unnecessary and a waste of everyone's time. Call me immediately so we can resolve this. The next one. Mr. Chen, I'm trying to work with you here, but you're making this very difficult. The board is willing to waive half the boot removal fee if you withdraw your lawsuit and register your vehicle properly. and the final one left at 9 that evening. Mr. Chen, you're making a serious mistake. The HOA has every right to enforce community standards, and we will vigorously defend ourselves against your frivolous lawsuit. You should also know that the board is considering a special assessment against your unit for legal fees. This could have been resolved simply, but you chose to escalate. That's on you. I saved all the voicemails and forwarded them to Patricia, then called her back despite the late hour. She answered on the second ring, sounding wide awake. Marcus, thanks for calling back. Did you get my message about the hearing? I did. I also got several messages from Brenda Carmichael that sound increasingly desperate. That's not surprising. I sent a copy of our filing to the HOA's registered agent this afternoon, and I'm guessing their attorney read them the Riot Act. What we're alleging is pretty serious, and if we can prove it, the HOA could face significant damages. Brenda mentioned something about a special assessment against my unit for legal fees. Can she do that? Patricia made a dismissive sound. She can try, but it won't hold up. You can't be assessed for the cost of defending against a legitimate lawsuit filed because of the HOA's own misconduct. That's retaliatory and illegal. If she does it, it's just more ammunition for us. There was also a message from the towing company. The guy sounded worried. I'm not surprised. I sent them a letter this afternoon as well, informing them that they may have participated in an illegal trespass and unlawful detention of property. I made it clear that we're not currently naming them as defendants, but that could change depending on their level of involvement. My guess is they're realizing they got played by the HOA and they want to distance themselves from this mess. Should I call him back? Not yet. Let's see what happens at the hearing tomorrow. Once we have the injunction, we'll have more leverage. In the meantime, just keep documenting everything. The hearing the next morning was held in Multnomah County Circuit Court. I'd taken the day off work, and I arrived at the courthouse 45 minutes early, dressed in my best suit. Patricia met me in the lobby, carrying a leather briefcase and looking every bit the competent attorney. Ready, she asked. As ready as I'll ever be. The courtroom was smaller than I expected, with about 20 seats for observers and a raised bench where the judge would sit. Brenda was already there, seated next to a man in an expensive-looking suit who I assumed was the HOA's attorney. She shot me a venomous look when I walked in, but I ignored her. Judge Raymond Blackwell entered at precisely 10 o'clock. He was an older man with gray hair and the tired expression of someone who'd seen every type of human pettiness imaginable. He sat down, adjusted his glasses, and looked at the paperwork in front of him. This is case number 26-4573, Chen versus Meadowbrook Heights Homeowners Association. I've reviewed the petition for emergency injunction. Miss Hoffman, you're representing the plaintiff. Patricia stood. Yes, Your Honor. And Mr. Garrett, you're here for the defendant. The HOA's attorney stood. That's correct, Your Honor. Maxwell Garrett representing Meadowbrook Heights HOA. All right. Miss Hoffman, this is your motion. Make your case. Patricia launched into a concise but powerful argument. She outlined the facts, showed photos of the boot on my car in my garage, quoted the relevant sections of Oregon law regarding HOA access to private property, and highlighted the fact that I'd never been given proper notice of the parking permit requirement. She concluded by arguing that the HOA's actions constituted an illegal trespass and unlawful detention of my property, causing ongoing harm that warranted immediate injunctive relief. Judge Blackwell listened without interruption, occasionally making notes. When Patricia sat down, he turned to Maxwell Garrett. Mr. Garrett, your response. Garrett stood, smoothing his tie. Your Honor, the HOA acted entirely within its authority as outlined in the community's CC and Artiques. All homeowners agree to abide by these regulations when they purchase property in the community. Mr. Chen's vehicle was in violation of clearly stated parking requirements, and the HOA took appropriate enforcement action. In his private garage, Judge Blackwell's tone was skeptical. The CC and Artiques grant the HOA access to all areas of the community for enforcement purposes. Mr. Chen signed those CC and Artiques when he purchased his property. Did the HOA provide notice before entering Mr. Chen's garage? Garrett hesitated. The ongoing violation itself provided sufficient notice of the need for enforcement action. Judge Blackwell removed his glasses and rubbed the bridge of his nose. Mr. Garrett, I'm going to stop you right there. I've been a judge for 23 years and I've seen a lot of HOA cases. This one is particularly egregious. Your client entered this man's private garage without notice, immobilized his vehicle, and is now demanding $400 for its release. That's not enforcement. That's extortion. Your Honor, I must object to that characterization. You can object all you want, but it doesn't change the facts. The injunction is granted. The HOA will immediately arrange for the removal of the boot at no cost to Mr. Chen. Furthermore, the HOA is enjoined from taking any retaliatory action against Mr. Chen, including but not limited to special assessments, fines, or restrictions on his use of his property. We'll schedule a full hearing on the merits in 30 days. Anything else? Patricia stood. Your Honor, we'd like to request attorney fees for this motion. Granted. The HOA will pay reasonable attorney fees associated with this injunction. Mr. Garrett, I suggest you have a very serious conversation with your client about their policies and procedures. This case should never have gotten to my courtroom. We're adjourned. The gavel came down with a sharp crack. I felt a wave of relief wash over me so powerful that my knees actually went weak. Patricia turned to me with a satisfied smile. That went well. Across the courtroom, Brenda was having a heated, whispered conversation with Maxwell Garrett, her face flushed red. He was shaking his head, looking deeply unhappy. As we gathered our things to leave, Garrett approached us. Miss Hoffman, might I have a word? Patricia glanced at me, then nodded. We stepped into the hallway, where Garrett loosened his tie slightly and sighed. Look, I'm going to be frank with you. I've been the HOA's attorney for 3 years, and this is the worst case of overreach I've seen from them. I advised Miss Carmichael not to contest the injunction, but she insisted. After that hearing, I think she's starting to realize the situation she's in. Is the HOA prepared to settle? Patricia asked. I think they might be. What would your client consider fair? Patricia looked at me. I thought about it for a moment, remembering Brenda's smug expression when she told me to pay the fee, her casual dismissal of my concerns, her threats about special assessments. I want a formal written apology from the HOA board, I said. I want the HOA to revise their policies to require 24 hours written notice before entering any private garage or unit except in genuine emergencies. I want a full refund of my attorney fees. And I want Brenda Carmichael removed as HOA president, Garrett winced. That last one is going to be difficult. The board is elected by homeowners. Then put it to a vote. Let the community decide if they want someone who thinks it's acceptable to invade people's private property in charge of the HOA. I'll discuss it with the board, but I should warn you, Miss Carmichael is not going to go quietly. I don't care, I said. She violated my rights and she needs to face consequences. We left the courthouse, and Patricia promised to follow up with Garrett in a few days to see if the board was serious about settlement. In the meantime, she'd continue preparing for the full hearing. True to the judge's order, I received a call that afternoon from Dave at Quick Lock Towing. His voice was apologetic. Mr. Chen, I'm calling to arrange removal of the boot from your vehicle. I can come by this evening if that works for you. That works. No charge, correct? No charge, and Mr. Chen, I want to apologize. We were given information by the HOA that turned out to be inaccurate. If I'd known the vehicle was in your private garage, I never would have sent my guy to boot it. I appreciate that, Dave. Can I ask you something? Did Brenda Carmichael tell you the car was in my garage when she requested the boot? There was a long pause. She told us the vehicle was parked on HOA property without a permit. She didn't specify that it was in a private garage. When we got there, our technician did think it was odd, but he had the work order, so he followed through. Would you be willing to testify to that if this goes to trial? Another pause, even longer this time. I'd have to think about it. We do a lot of work for HOAs in the area, and I don't want to burn bridges. But between you and me, what happened to you was wrong. So yeah, if it comes to it, I'll tell the truth about what we were told. That's all I can ask. Thanks, Dave. He arrived at 7 that evening with a younger guy who did the actual work of removing the boot. The whole process took maybe 10 minutes. Dave handed me a receipt marked "No charge per court order" and shook my hand. Good luck with your case, he said. For what it's worth, I hope you win. After they left, I sat in my car for a few minutes, just enjoying the fact that it was mobile again. Then I took one final photo of my unblemished wheel and sent it to Patricia with a thumbs-up emoji. Over the next week, things got interesting. Word of the lawsuit spread through the community like wildfire. I started getting emails and texts from neighbors I'd barely spoken to, most of them expressing support and sharing their own stories of Brenda's overreach. One woman, Sandra Martinez from Unit 12, told me that Brenda had fined her $300 for having the wrong color welcome mat. Another homeowner, James Wu, said he'd been threatened with a lien on his property for painting his front door a shade of blue that Brenda deemed not in keeping with community aesthetics. The stories kept coming, each one more ridiculous than the last. Brenda had apparently been running the HOA like her personal fiefdom for years, and people were terrified of her. She had a reputation for being vindictive, and homeowners who crossed her often found themselves facing a barrage of fines and violations for the most minor infractions. I compiled all these stories and forwarded them to Patricia, who was delighted. "This is perfect," she told me over the phone. "It establishes a pattern of abuse of power. If we go to trial, these people could testify about the toxic environment Brenda has created." But we didn't get a chance to use that testimony right away. 3 days after the injunction hearing, Maxwell Garrett called Patricia with a settlement offer. The HOA would pay my attorney fees, issue a formal apology, and revise their access policies as I'd requested. However, they were not willing to remove Brenda from the board. "Not good enough," I told Patricia when she relayed the offer. "Brenda is the problem. As long as she's in charge, this is going to keep happening." "I agree, but we can't force the board to remove her. That's up to the homeowners. Then let's make sure the homeowners have all the information they need to make an informed decision." With Patricia's help, I drafted a letter to every homeowner in Meadowbrook Heights. In it, I outlined what had happened to me, referenced the court's injunction, and shared some of the stories other homeowners had told me about Brenda's conduct. I concluded by calling for a special meeting to vote on Brenda's removal from the board and to discuss reforms to the HOA's governance. Oregon law allowed homeowners to call a special meeting if they could get signatures from at least 20% of the community. Meadowbrook Heights had 86 units, so I needed 18 signatures. I got 43. The special meeting was scheduled for 3 weeks later to be held in the community clubhouse. In the meantime, Brenda went into full damage control mode. She sent out her own letter, claiming that I was a troublemaker who was trying to undermine the HOA over a simple parking violation. She argued that the rules existed for everyone's benefit, and that enforcing them was her job as board president. What she didn't count on was the fact that a lot of people were really, genuinely fed up with her behavior. The more she tried to defend herself, the more people came forward with their own horror stories. A Facebook group called Meadowbrook Heights HOA Reform sprang up and quickly gained over 60 members. People shared photos of ridiculous violation notices, complained about arbitrary fines, and vented their frustrations. The night before the special meeting, I got a call from an unknown number. When I answered, a woman's voice said, "Is this Marcus Chen?" "Yes, who is this?" "My name is Linda Patterson. I used to be on the HOA board with Brenda Carmichael. I resigned 2 years ago because I couldn't deal with her anymore. I heard about the special meeting tomorrow and I wanted to offer my support." "I appreciate that, Linda. Can I ask why you resigned?" Brenda is a bully. She sees the HOA as her personal kingdom, and anyone who disagrees with her gets steamrolled. I tried to push back on some of her more extreme policies, and she made my life hell. She filed violation notices against my property almost weekly, always for things that were either completely made up or incredibly petty. Eventually, I just gave up and resigned. It was easier than fighting her. "Why didn't you say something? Why didn't other board members stand up to her?" Linda sighed. "Because she's relentless. And honestly, most of the board members are just people who don't want to be there. They got elected because nobody else wanted to do it, and they just rubber stamp whatever Brenda wants because it's easier than arguing. But what she did to you crossed a line. If you need me to speak at the meeting tomorrow, I will. That would be incredibly helpful. Thank you." The special meeting was standing room only. Every seat in the clubhouse was filled, and at least 20 people were standing along the walls. I'd never seen this level of engagement from the community, and judging by Brenda's expression, neither had she. She sat at the front table with the other 2 board members, both of whom looked deeply uncomfortable. I'd been designated to chair the meeting since I'd organized it, so I stood at a podium and called things to order. "Thank you all for coming. We're here tonight to discuss concerns about HOA governance and to vote on a motion to remove Brenda Carmichael from her position as board president. Before we vote, we'll have an open comment period where anyone can speak. Please keep your comments respectful and stick to facts." The first person to speak was Sandra Martinez, the woman who'd been fined for her welcome mat. She described the violation notice she'd received and the threatening tone of Brenda's follow-up emails. Next was James Wu, who talked about being told his door color was unacceptable despite there being no specific color requirements in the CC and Articles. One by one, homeowners stood up and shared their experiences. Some were angry, some were tearful, but all of them painted a picture of an HOA president who had completely lost sight of her role. When it was Linda Patterson's turn, she didn't hold back. "I served on the board with Brenda for a year and a half, and it was the most miserable experience of my life. She doesn't see herself as a servant of this community. She sees herself as a ruler. She makes decisions without consulting the other board members. She retaliates against anyone who questions her, and she interprets the CC and Articles in whatever way serves her interests at the moment. What happened to Marcus Chen was wrong, but it wasn't an isolated incident. It's part of a pattern that's been going on for years." By the time the comment period ended, Brenda's face was pale. She stood and tried to defend herself, but her arguments fell flat. She claimed she was just enforcing the rules, that people didn't understand how hard her job was, that she'd given years of service to the community, and this was how she was being repaid. Nobody was buying it. When it came time for the vote, the result was overwhelming. 68 homeowners voted to remove Brenda from the board. 7 voted against, likely her few remaining friends in the community. 11 abstained. The motion passed. Brenda stood, grabbed her purse, and walked out without another word. As the door closed behind her, the room erupted in applause. In the aftermath of the vote, the remaining board members appointed Linda Patterson as interim president. One of her first acts was to accept the settlement terms Patricia and I had proposed. The HOA issued a formal written apology, revised their access policies to require proper notice, and paid my attorney fees in full, which came to just over $8,000. But the story didn't end there. About 2 weeks after the special meeting, I got another call from Patricia. "Marcus, you're not going to believe this. I just got a very interesting phone call from the county prosecutor's office." "About what?" "About Brenda Carmichael. Apparently, after your case got publicity, several other homeowners came forward with complaints. The prosecutor is investigating whether Brenda misappropriated HOA funds." I sat up straighter. "Misappropriated how?" "That's still being investigated, but the preliminary evidence suggests she was using the HOA's credit card for personal expenses. Dinners, shopping trips, even a weekend getaway to Cannon Beach. She apparently thought because she was board president, she was entitled to these perks. The total amount is somewhere around $12,000 over 2 years. Is that enough to press charges? Definitely, that's theft. If the prosecutor can prove it, Brenda could be looking at criminal charges. The investigation took about 6 weeks. During that time, an independent audit of the HOA's finances was conducted, and it revealed that Brenda had been far more creative with the HOA's money than anyone had realized. Beyond the personal expenses on the credit card, she'd been paying herself an unauthorized salary of $500 a month, claiming it was compensation for her time as board president. The CC and Articus explicitly stated that board positions were volunteer and unpaid. In total, Brenda had taken roughly $24,000 from the HOA over a 3-year period. The audit also revealed that she'd been approving contracts with vendors who gave her kickbacks, including the landscaping company that maintained the common areas. The Multnomah County District Attorney's Office filed charges in late May. Brenda was charged with theft in the first degree, a Class C felony, and fraudulent use of a credit card. The case attracted local media attention, with the headline "HOA President Accused of Embezzling Thousands" appearing in the Oregonian. I didn't take any pleasure in Brenda's downfall. Part of me actually felt sorry for her, but I also knew that what she'd done was wrong and that accountability was necessary. The criminal case moved slowly, as these things do. In the meantime, I got back to my normal life. Work at the hospital was as demanding as ever, but I found that I actually enjoyed coming home to Meadowbrook Heights now that the oppressive atmosphere Brenda had created was gone. Linda Patterson was doing an excellent job as HOA president, focusing on actual community improvement rather than petty enforcement of arbitrary rules. The full hearing on my civil case was scheduled for August. I honestly didn't expect it to go forward, since the HOA had settled most of my claims, but Patricia explained that we were still pursuing damages for emotional distress and the invasion of privacy. More importantly, we wanted a court ruling that would set precedent and prevent other HOAs from pulling the same stunt. The hearing was held on a sweltering Thursday afternoon. Judge Blackwell was once again presiding, and he seemed to remember our case from the injunction hearing. This time, the HOA had a different attorney, since Maxwell Garrett had apparently decided he didn't want to defend the indefensible. The new attorney, a woman named Rebecca Stone, was professional but clearly aware she had a losing hand. She made a half-hearted argument that the HOA had acted in good faith based on their interpretation of the CC and Articus, but Judge Blackwell wasn't having it. "Miss Stone, we've already established through the injunction that your client violated Mr. Chen's rights. The The question now is what damages he's entitled to. Miss Hoffman, what are you asking for?
Patricia stood.
Your Honor, we're seeking $10,000 in compensatory damages for emotional distress and invasion of privacy, plus a declaratory judgment that the HOA's actions violated Oregon's Planned Community Act. Judge Blackwell nodded. Mr. Chen, would you like to address the court regarding the impact this situation had on you? I stood, my heart racing. Public speaking had never been my strong suit, but I'd prepared for this. Your Honor, I'm a physician. I work 12-hour shifts in an emergency room dealing with life and death situations. When I come home, I need to be able to relax and recharge. What Brenda Carmichael did made me feel violated in my own home. For weeks, I didn't feel safe in my own garage. I was anxious and angry, and it affected my work and my personal life. Beyond that, the principle matters. If an HOA can enter someone's garage without notice and hold their property hostage, what else can they do? This wasn't about a parking sticker. It was about power and control, and it was wrong. Judge Blackwell listened carefully, then turned to Rebecca Stone. Does the HOA wish to present any evidence or testimony? No, Your Honor. All right, here's my ruling. The HOA's actions were clearly unlawful and constituted a serious invasion of Mr. Chen's privacy and property rights. I'm awarding compensatory damages in the amount of $10,000. I'm also issuing a declaratory judgment that the HOA violated Oregon Revised Statutes Section 94.640 regarding HOA access to private property. The HOA is ordered to pay Mr. Chen's attorney fees and costs. This decision will be published and can be cited as precedent in future cases. Court is adjourned. Patricia and I shook hands, both of us grinning. As we left the courtroom, Rebecca Stone approached us. Miss Hoffman, Mr. Chen, the board wanted me to convey their apologies once again. The new leadership is committed to making sure nothing like this ever happens again. I appreciate that, I said. And for what it's worth, Linda Patterson is doing a great job. I actually like living in Meadowbrook Heights now. We walked out into the bright August sunshine, and I felt a weight lift off my shoulders that I hadn't even realized I'd been carrying. But there was one more chapter to this saga. Brenda Carmichael's criminal trial was scheduled for October. The prosecutor's office had offered her a plea deal. Plead guilty to a reduced charge of theft in the 3rd degree, pay full restitution to the HOA, and serve 2 years of probation. Brenda rejected the offer, insisting she'd done nothing wrong. The trial lasted 3 days. I attended part of it, sitting in the gallery and watching as the prosecution methodically presented their case. They had bank records, credit card statements, emails, and testimony from the HOA's accountant. The evidence was damning. But the moment that stood out to me was when Dave from Quick Lock Towing took the stand. The prosecutor called him as a witness, and he testified about the work order he'd received from Brenda to boot my car. Can you describe what information you were given by Miss Carmichael? The prosecutor asked. Dave looked uncomfortable but determined. She told us there was a vehicle parked on HOA property without a permit. She said it had been there for several days and needed to be booted immediately. She gave us the address and unit number. Did she specify that the vehicle was in a private garage? No, she did not. If she had, I would have questioned whether we had the authority to enter private property. When our technician arrived and saw that the car was in a garage, he called me. I told him to proceed because we had a signed work order from the HOA president. In hindsight, that was a mistake. Why do you say it was a mistake? Because what we did was wrong. We entered someone's private garage and immobilized their vehicle based on misleading information. Mr. Chen had every right to be angry, and I'm just glad he didn't sue us along with the HOA. The defense attorney tried to argue that Dave's testimony proved Brenda hadn't done anything wrong, since she'd simply hired a towing company to enforce HOA rules. But the prosecutor countered by pointing out that Brenda had deliberately withheld information from the towing company to ensure they'd carry out an action that she knew was legally questionable. When it was Brenda's turn to testify, she was defensive and evasive. She insisted that everything she'd done was for the good of the community, that people just didn't appreciate how hard she worked, that she deserved to be compensated for her time. When the prosecutor showed her receipts for personal dinners and shopping trips charged to the HOA account, she claimed they were legitimate business expenses because she'd sometimes discussed HOA matters during those meals. The jury deliberated for less than 4 hours. They found Brenda guilty on all counts: theft in the first degree and fraudulent use of a credit card. Sentencing was scheduled for 6 weeks later. I wasn't in the courtroom for the sentencing, but Patricia called me afterward to fill me in. Judge Maria Santos, who had presided over the criminal trial, sentenced Brenda to 3 years in prison, with eligibility for early release after serving 18 months. She was also ordered to pay full restitution to the HOA, which came to $24,000 plus interest, and to cover the cost of the independent audit that had uncovered her theft. In her sentencing remarks, Judge Santos was blunt. "Miss Carmichael, you were given a position of trust by your community, and you abused that trust in multiple ways. You stole from your neighbors, you violated their privacy, and you created an atmosphere of fear and intimidation. Your actions went far beyond simple theft. You undermined the entire concept of community governance. The sentence I'm imposing reflects the seriousness of your crimes and the need to deter others who might think they can use HOA leadership positions for personal gain." Brenda was led out of the courtroom in handcuffs. According to news reports, she showed no emotion. The fallout from Brenda's conviction rippled through the Portland HOA community. Several other HOA boards hired independent auditors to review their finances, worried about what they might find. The Oregon State Legislature introduced a bill that would require HOAs to undergo annual independent audits and provide more transparency about their financial operations. The bill passed in March of the following year, directly citing my case and Brenda's conviction as the impetus. As for me, life gradually returned to normal. I kept working at the hospital, kept living in my townhouse at Meadowbrook Heights, and tried to put the whole ordeal behind me. The $10,000 in damages went toward paying off some medical school debt, and I donated a portion to a legal aid organization that helps homeowners fight abusive HOAs. Linda Patterson served as HOA president for 2 years and did a fantastic job. She simplified the rules, improved communication with homeowners, and actually made the community feel like a community rather than a prison camp. When she decided not to run for re-election, I actually considered running myself, but ultimately decided I didn't have the time given my work schedule. I still see Dave from Quick Lock towing occasionally. His testimony in Brenda's trial had been a turning point, and I made a point of thanking him for his honesty. He told me that after everything that happened, his company revised their policies about accepting HOA work orders. Now they require detailed information about where a vehicle is located and verification that the HOA has legal authority to request a boot or tow. "What happened to you opened my eyes," he told me over coffee one afternoon. "I always thought HOAs were legitimate authorities, that they knew what they were doing. I never questioned their work orders. Now I do. We've actually turned down several jobs from HOAs because the situation seemed sketchy. I'm glad something good came out of it," I said. About a year after Brenda's sentencing, I ran into Maxwell Garrett, the first attorney who'd represented the HOA. He was at a legal conference I was attending as a panelist on medical malpractice issues. During a break, he approached me. "Dr. Chen, I wanted to apologize for how I handled your case initially. I should have recognized immediately that what Brenda did was indefensible. I let my loyalty to a long-term client cloud my judgment." "I appreciate that," I said. "For what it's worth, I know you were just doing your job." "I've actually stopped representing HOAs entirely," he admitted. "After your case and Brenda's conviction, I realized that too many HOA boards see themselves as mini-governments with unlimited power. I don't want to be part of enabling that anymore. I've shifted my practice to business law." "That's probably a healthier area of law," I said with a smile. "As I write this, it's been almost 3 years since I found that boot on my car." Brenda served 16 months in prison and was released on parole in early 2027. I have no idea what she's doing now, and honestly, I don't care. I hope she's learned from her mistakes, but that's not my concern. What I do know is that my case made a difference. I've received emails and messages from people all over Oregon and even other states, thanking me for standing up to HOA abuse. Some of them have shared their own stories of fighting back against overzealous HOA boards, citing my case as inspiration. The legislative changes that came out of it have made HOAs more accountable and transparent. But more than any of that, I'm proud that I didn't just pay the boot fee and move on. It would have been easier, it would have been cheaper, at least in the short term, but it would have been wrong. Brenda Carmichael needed to be held accountable, and the system needed to be changed. Sometimes I still park my car in my garage and think about finding that yellow boot clamped to my wheel. It seems almost surreal now, like something that happened to someone else. But then I remember the anger I felt, the violation, the sheer audacity of someone thinking they had the right to enter my private space and hold my property hostage. And I remember that standing up for yourself, even when it's hard, even when it's expensive, even when everyone tells you to just let it go, is sometimes the most important thing you can do. The Meadowbrook Heights community is thriving now. The pool and gym are well maintained, the landscaping is beautiful, and the atmosphere is friendly and welcoming. People actually talk to each other instead of living in fear of violation notices. The current HOA board operates with transparency and respect for homeowners' rights. Last month, there was a community barbecue by the pool. I went, not because I had to, but because I wanted to. I stood there with a plate of hamburger and potato salad, chatting with Sandra Martinez and James Wu and a dozen other neighbors, and I thought about how different things could have been if I'd just paid that $400. But I didn't pay it. I fought back, and in the end, justice prevailed. My Tesla still parks in my garage every night exactly where it belongs. No boot, no sticker, no harassment. Just my car in my garage in my home, and that's exactly how it should be.